So now we go to
Miller versus,
Miller versus Harvey.
and I'm Alan Johnson. I represent Mr. Harvey, and I would like to reserve 5 minutes for rebuttal.
All right.
As the court knows from reading the briefs, this is an action for specific performance of an oral contract for the sale of land. And I've raised several reasons in the brief why that specific enforcement of the contract should not be upheld by this court. But there are two reasons I want to focus on my limited time today. First one is that Ms. Miller's claim is barred by the doctrine of judicial estoppel. And what triggers that doctrine is that the plaintiff failed to disclose oral contract in her bankruptcy petitions. Oral contract is an asset, and she failed to disclose that in her bankruptcy pleadings in the initial petition. And I believe it's never been amended to advise the bankruptcy court of this asset.
Were there any findings by the district court about this bankruptcy, failure to disclose to bankruptcy?
No, there were no specific findings.
And do we have the bankruptcy record to know exactly what happened, when, where, and how on that bankruptcy?
I don't believe we do have there. It's not in the record. Now, there is testimony, which I've cited in my brief about she was cross-examined about what that was.
Right.
And my suggestion is if
And her argument was this was not purposeful. I was relying on my attorney. How do we adequately review that as an appellate court just on that thin evidence?
Two ways. Number one, it's a legal doctrine. And if you read the federal cases, there's a long list of them that I cited. And just from the 10th Circuit, they all say if a debtor does not disclose it in the bankruptcy petition, they are judicially stopped because the bankruptcy petition specifically requires under oath the debtor to disclose all assets. And the federal court said if you don't disclose all those assets, typically a lawsuit, you cannot then go file a lawsuit separate and apart from the bankruptcy, because that's an asset of the bankruptcy. Your creditors are entitled to a share of whatever that is.
And if a court decides that you failed to disclose, there's no intent requirement, or it's either disclosed or not disclosed.
Correct.
Period. No discussion as to if she relied on her attorney, and the attorney didn't disclose. That's not.
Federal courts have been very strict about this because they say that inadvertence from a legal point of view, you say, well, I knew I had a lawsuit. I knew I had a claim, but I just didn't know I had to disclose it. Well, the answer court says is the petition or the instructions for petition of bankruptcy are very clear about you have to report all kinds of assets, and they list all of them.
To make a finding that the oral contract was the thing and that she did fail to disclose it without having any of that before us.
It's the testimony isn't before you. And what I would suggest, if you don't think
Records.
Do
we have the papers of it?
No, you have her testimony. She testified she did not disclose it in the bankruptcy. Now, if you think that's adequate, I would suggest that because this really goes to the integrity of the judicial process itself, you can remand it back to the court and say, here's what we see as judicial estoppel. Now, the Kansas state courts have not adopted the strict view that the federal courts had. But it's been raised here. It can be raised on appeal because it is not an affirmative defense. It goes to the integrity of the judicial process itself. So in your discretion, if you say, well, we think it should be considered, you can remand it back to the district court to say, here are the guidelines. Here's the law as we see it, as we interpret it under Kansas law. And we need you to make additional findings on whether there was. And there's three different factors, and both the state courts and the federal courts follow a case that the U.S. Supreme Court issued, New Hampshire versus Maine, that has all those. It goes through in detail, and all the federal courts and state courts, this court as well, has There's one Court of Appeals case I cited, which looks at judicial estoppel, cites the New Hampshire case, but it's not factually similar to what this is here. And I would point out this is not unfair to the plaintiff because the trustee in bankruptcy, as the cases say, is not barred by the doctrine of judicial estoppel. If it's applied in this case, Ms. Miller could substitute the trustee to pursue that claim, which is really the proper party in interest because she's still in bankruptcy. The trustee should pursue that for the benefit of the bankruptcy and not and for the benefit of the creditors. That's part of the fraud is that she, and they use the term fraud, is that she is getting an asset while in bankruptcy and is not sharing it with her creditors.
Well, unless there's an amendment to the filing.
That's true, but even in some of the cases, the amendments to filings don't.
Well, in some of the cases, but let's say, we say she gets the property, then the bankruptcy trustee get it that way, right?
That's true. We notified the bankruptcy trustee and asked him to come into this lawsuit and substitute himself. Well, he hadn't done it so far. So we said, well, let's wait and see what the
Because there was evidence that she subsequently amended the filing, right? And you're saying that doesn't cure it.
Well, her testimony is not clear. She says that I gave the information to my lawyer. She was cross-examined and said, did you amend it? And she said, I don't know. No. And she specifically asked, did you just in your current?
And did you have any contrary evidence to present that she didn't amend it?
Well, I was not
But
trial
counsel.
Trial counsel did ask her, did you disclose
I
the
understand
payment?
they asked.
Yeah.
And
And she said there is nothing in the bankruptcy petition, even as amended, showing that I'm making payments on the mortgage or that I made payments for the improvement of property.
So it was amended.
There was an amendment.
Oh,
She testified that it was amended. How it was amended is not clear. But what is clear is that
isn't that the point?
Something we would need to know.
again, that's why I say that you can take judicial notice if you go and look at her, which is what the federal courts do all the time. They take judicial notice of the bankruptcy filings.
Well, federal court.
Yeah, my only concern is, do we have enough record for us to make any determination on it? Was it developed enough below for us to review that?
I contend you do.
Okay.
But if you don't think you do, then
Then you want
I
us to
suggest
remand it and
remand it back
give
to
another bite of the apple.
find out what it is.
All right.
Now, the second reason why the oral contract should not be enforced is because it's barred by the statute of frauds. KSA 33106 expressly bars specific performance of oral contracts plan. Now, over the years, Kansas Supreme Court has recognized certain exceptions. And one of those exceptions is partial performance. And that's what the district court found here was that Ms. Miller made repairs and improvements to the property. And therefore, there was partial performance. Now,
I don't know how to stop that. Turned it down. Go on.
well, the reason why that is erroneous is that the Kansas Supreme Court, in applying that rule, the Bank of Alton, which I cited, said in order for partial performance to remove a case from the statute of frauds, there must be evidence and a finding that the seller consented to it, knew about it, and consented to it. And in this case, it's uncontroverted that Ms. Miller never told Mr. Harvey that she was making those improvements, and therefore he could not have consented. That's her own testimony. She was asked on.
The counter to that is she said, I can't remember what her words were early on in this process. And he said, basically, it's yours. There was some allegation that his statement was, it's yours, do whatever you want.
Problem,
He had
yes.
washed his hands of it at that point, and he may not have known specific things that she was doing, but he gave permission, basically, do what you want, it's yours now.
Well, there was testimony to that effect. The district court had very limited findings of fact. There was no finding of fact as to the amount of the repairs, nor was there any finding of fact that he knew about it, or a finding of fact that he told her that. There was a dispute between, he denied ever telling her that. She testified to that fact, and the district court made no finding of it. So based upon the rule that in order to show part performance, partial performance is an exception, there has to be a factual finding that the seller was aware of and knew about it.
And so did you file anything at the end of the case requesting additional fact finding?
No.
I mean, you generally, we assume the court found what it needed to find to reach the decision it reached, unless you filed something to say you wanted more definitive, or
That was
whoever
not,
trial counsel
no,
was.
that was not filed at the trial.
Okay.
But again, this was an equitable proceeding, and the court has unlimited review of the application of the statute of frauds. And I contend, if you read particularly the Bank of Alton cases and the cited in there, the Supreme Court has been clear that there has to be consent and acquiescence. Otherwise, it's not equitable to specifically inform a contract. I want to point out, and one of my other arguments is that even if you find that it should not be specifically enforced, that doesn't mean that the plaintiff is without a remedy. I've cited cases that saying she is entitled for restitution for the repairs and additions to the property on a quantum merit basis. That's the proper way I contend this should occur, because there's nothing special about this property other than everybody thinks their own property is special, but she can be compensated in monetary damages without enforcing an oral contract for the sale of land that's expressly prohibited by statute of frauds. So those are my arguments. I'd like to reserve whatever time I have unless the court has.
Have 5 more minutes, so.
Okay.
Okay, thank you.
All right, thank you.
Quinn?
May it please the court. We know that this was a trial to the bench.
Can I ask you to speak up just a little? As we've said, we have these fans going behind us and it's hard for us to
Yes.
hear, so.
We know that this was a trial to the bench.
Mhm.
Judge Harvey heard all of the evidence. She could get to make, and she did make determinations on the evidence. And this court should presume that she made all the findings necessary to support her decision that a valid oral contract had been entered into. And what the defendant appellee is asking this court to do is to reverse her decision when it did not ask the court to make any specific findings, and he's raising arguments at this point that were never raised or preserved in the district court. The defendant had every opportunity to raise a judicial estoppel argument before Judge Harvey.
So he raised the issues of the bankruptcy, but he didn't make a judicial estoppel argument?
He did not. And I believe his entire position was that, oh, she filed this bankruptcy and she didn't
Ability, yeah.
She didn't tell the bankruptcy court of her interest in this property. Therefore, Your Honor, you should deny her petition in this case and give us the property. That's really what he was saying. And if he had a legitimate judicial estoppel issue, he should have raised it in his answer. He should have raised it in a separate motion. But he only talked about how she didn't disclose it in a bankruptcy.
Because arguably, had he made those arguments of judicial estoppel, the court could have ferreted out the record a little more. Is that what you're saying?
Absolutely, Your Honor. But more so than that, I believe the cases that were cited dealt with bankruptcy court. The plaintiff was in bankruptcy. The defendant was not a creditor in bankruptcy. He could have taken his issue to the bankruptcy court if he thought he was a creditor. The record is devoid of any of that, but he wants you to make a decision because an issue he never raised in the lower court, you should decide in their favor. I don't think that's appropriate in this case. Your Honors, he's also saying that because this oral agreement was not in writing, it's beyond the statute of frauds. We know that there are some circumstances that will remove a real estate agreement that's not in writing out of the statute of fraud. And Judge Harvey found that those facts existed in this case. There was knowledge, consent, or acquiescence all over this case. And I believe what the defendant is saying is because she did not call me every time she made a repair, somehow it removes it out of that exception. I disagree. What we have is a situation where the plaintiff discovered that this real estate was substantially delinquent and on the verge of foreclosure. The defendant told him he was done with it, he didn't care about it. And what happened after that? They obviously entered into an agreement because you don't lease a property and bring current $9,000 of cash due mortgage payments. You don't make all the improvements on the property. That just doesn't happen. And not only that, even if she didn't make these improvements with his knowledge or consent, she did everything else. Everything else. And she brought all of those mortgage payments current.
What's the impact of him providing her all of his private information to provide to the bank?
It's significant, Your Honor. No one does that for a tenant. She didn't get this information on her own. He agreed with her at every process until after he brought this property that, of course, I consider expensive. It may not be to anyone else in Shawnee County. And he said, aha, we don't have a written agreement. So there's no way she can prove we had the written agreement for her to purchase this property. So he puts it up for sale.
Oh, so you're saying you put it up for sale so he could buy a piece of property somewhere else?
Yes, he wanted the money.
Mhm.
That's what he did. And he bought the property from his trial attorney. And before that, they never had any problems or misunderstandings. But she did all of this, Your Honors. And now he wants to take the property. She did more than he had ever done, more than any tenant had ever done. And it's incredible to think anyone would believe that she did all of this if she didn't think she owned the property, if there was not an agreement. But our case goes beyond that. Ms. Miller has exceeded the partial performance. She has complied with the agreement they had. She even deposited the amount of money that was due in January of 2025 into the court. The only thing left to be done is from him. He needs to give her that quitclaim deed. Now, the defendant is saying, well, restitution is an option. Well, first of all, there was no testimony about the value of the property when the agreement was made in 2020, but he never raised the restitution issue in the district court. But restitution is applicable when the court determines there is no specific performance. The court didn't rule that in this case, made a specific finding that it should be specific performance in this case. But again, I think many of the issues that the defendant is raising, they're raising them for the first time on appeal, and they're asking you to just agree with them for whatever reasons. So, Your Honors, if you have any questions, I'll answer it, but I think in a nutshell that all this man has to do is to transfer that quitclaim deed to my client. He got all.
Initiate the lawsuit as soon as she found him putting the for sale sign out front.
That and other terrible things. He actually had the utilities turned off.
That's right. He had the day he put the sign up, he had the utilities turned off.
He actually came on the property even after there was a restraining order. He was trying to get.
This is all in the record.
Oh, yes.
Okay.
Yes, it is. Trying to get the son evicted. He fought with the son, threatened the son, because he wanted this property. He wanted to sell it. He wanted the money, even though he had said he was done with it. A person who wants to keep their property, I don't think would allow it to get that far behind and give a person their personal information so that it would put them in a position to buy the property. I just don't think that's credible. But Judge Harvey heard all of the evidence. She got to determine the demeanor of all of the witnesses. And Judge Harvey made a determination that this contract should be specifically performed. And if there are any finding absences, it's clear to me it's because the defendant did not want specific findings on these issues so that they could come before you and criticize there were no specific findings. Okay. Thank you. Oh, I'm sorry.
Questions? Thank you.
Thank you.
All right, rebuttal.
Thank you, Judge.
She's hit on exactly what I asked you at the end is you're saying she didn't make findings, but trial counsel didn't ask for more specific findings.
Well, that is because that's an exception to the statute of frauds, and that was the burden of the plaintiff to make the specific findings. The statute of frauds says this oral contract would be void. Now, there is an exception to that, but in order for that exception to the statute to apply, there has to be a specific finding that the seller was aware of the partial performance and consented to it. That's what the Bank of Alton, it's what the Supreme Court said, the Bank of Alton. Now, in this case, there are only 8 findings of fact. There's lots of testimony. Both sides have done that, but there are only 8 findings of fact. And the only one that applies to specific performance is very short. It says plaintiff took possession of the property made improvements to the driveway, arena, fencing, plumbing, and installed new appliances.
I don't think Altman says that we still get to presume the district court made the finding. Altman doesn't say that we don't get to presume that.
Well, but the court didn't make that findings. There were only 8 findings, and in order to get into the exception, you have to make that finding. That's what's different on this.
She made the finding because she got to the exception.
Right.
Well, but she made no finding of fact that he knew about those improvements, and she couldn't have because
But isn't that why we have the rule that says if nobody objects to the findings that are made, we assume they made the findings necessary to get to the conclusion she got to?
in a general presumption, but not when you're trying to fit into an equitable exception under a statute
Say
that would.
exception to that rule in Altman.
Yeah. And which they've recognized. And they said that in order to get into that exception, because it is an exception to statute, the evidence has to be clear and has to fit into this category. And if there's no finding to that effect, then you can't fit under the exception.
It's different than having evidence. Having the judge write a finding out that states that is different than there being evidence to support it.
Well, true, but that doesn't mean the court found that. And my contention is, if you read the Bank Involvement and the other cases in which it's a limited exception to a clear statute, they say that there has to be a finding that the seller knew about it and consented to it. Otherwise, it's not equitable. It's not fair. Therefore, you have to apply the statute that expressly says this kind of a contract is void. Can't be
You
specifically.
talk a lot about equity here.
Mhm.
And just looking at the facts of these cases, not looking, I mean, the facts of this case and not looking at any of the legal issues, the facts of this case sure don't smell right. I mean, this woman and her son did a lot to this property. They advised him it was about to go into foreclosure. It's on an equitable basis, it seems rather appalling that the next thing they know, he's put a for sale sign out in front.
Well, as I argued in the first brief, I disagree with that because what happens in this case, she gets property that he testified was worth $150,000. She gets it for paying the mortgage of $49,000.
He says that now after all the repairs, but there's no mention of $150,000 at the beginning of this. It seems like there was an 88.
Well, when he first purchased it.
Right.
And the business
And he
about,
was saying, I want what I purchased it for less what I owed or something. Wasn't there something about?
well, that was her version of what it was.
Okay.
But what she gets, her testimony was, my agreement was I would pay the mortgage, which is $49,000. I pay $19,000, so around $68,000. And I get a piece of property that it's at its current value is 150. He bought it. He said when he first started, the mortgage was 77, and that back in 2020, the value of the property was $100,000. So the equity favors him because she's getting a windfall. She's getting property worth between 100 and 150 for $68,000.
It wasn't really worth that when she took it over.
Right.
though.
Right.
It was in a considerable state of disrepair. And so when you consider everything that she poured into this home to make it habitable, again, to the question of equity.
Well, in terms of equity would make it fair if she gets paid, if she gets monetary damages for that amount.
Is he even solvent where he could pay monetary damages?
Yes, he owns other pieces of property. That would be in order. She would.
If he has other pieces of property, he's a savvy property person.
Yeah.
So he knows what he's doing.
He knows what he's doing. And he said, I'm done with it.
Well, he testified, that was her testimony. He disputed that, and the
Okay.
district court never made a finding specifically as.
So the reason she would have paid $49,000 for them would be just
Take
for
over
the
the mortgage.
It was a
pleasure of living there.
No, because, well, all of the tenants, and the court found this, all of the tenants paid the mortgage rather than paying him rent. That was the sixth finding, I think, that she made. That says all the tenants
Going forward.
paid
The back.
mortgage.
For the,
Now, she,
an amount. It wasn't she in with the bank? I mean, the bank knew she was now the new.
yeah, she brought it up
That's a lot
about,
different than being a tenant.
she brought it up about $10,000.
so, but she paid this money to have the pleasure of paying more money?
No, because the mortgage was in arrears, and so she reinstated the mortgage.
For him.
40 It's still in his name. Yeah, she didn't want it in her
But she
name.
had to have something done.
Right. Her intent was to reinstate the mortgage for him to have the
Right.
mortgage.
And she did,
I see.
but the mortgage is in his name.
I understand.
And so, but the mortgage is $49,000. She pays
So if the
19.
mortgage was always in his name, why would she have to report it in her bankruptcy case?
Well, because she was paying, and in bankruptcy, you have to disclose payments you made. All kinds of payments.
No, you said she would have to disclose it because.
It was an asset.
In
Uh,
order for us to go with your judicial stop argument, wouldn't we have to determine that it was her, that the contract favored her and she had a contract for property?
Yeah, an asset she had.
An asset.
yeah,
Well, it's,
I'm not saying she has an asset. She's put money into the property that has improved the party. My contention is,
When I'm leasing a property, that's not my asset.
I understand, but this is quantum merit. She's entitled to restitution. We're not saying she's not entitled to money.
Arguments are different.
very different.
This judicial estoppel argument, what do you say to the fact that judicial estoppel should have been brought up to the district court?
It is not an affirmative defense. It can be raised in the discretion of the court on appeal. I cited 10th Circuit
And
case
did
in
you
which.
list in your brief
An
one of the
exception?
exceptions to why we should hear an unpreserved claim?
Well, because it's not an affirmative, because it
Have to
goes
be
to
a.
the integrity of.
It's just if you have a claim that you're gonna bring up here, you have to have brought it down there. It's a preservation issue. And if you didn't preserve it, you're required to give us one of the three exceptions as to why we should consider it, even though it wasn't preserved. So the question is, did you do that?
Do what? One of the
Just
reasons,
why we should hear it now when the district, because this whole idea of preservation is to give the district court a chance to fully examine all the issues. It sounds very clear to me that the district judge did not have an opportunity to fully evaluate this judicial estoppel issue because it wasn't raised as such. So if you are going to raise it on appeal, you have to tell us why we should hear it on appeal for the first time. And we only have 3 reasons why we can hear something on appeal. And you have a duty to tell us which one.
well, one of them is, you can,
The question is, did you say it in your?
legal issue. I believe, but,
Hey, this is a purely legal issue on admitted facts. Okay.
and again, in the context of how the federal courts view that, they have that same thing. And
Right.
that's how they addressed it as one of the exceptions, because it's a legal issue. It's an equitable issue, and it goes to the court's own
Okay.
But
integrity.
it's a purely legal issue based on proved or admitted facts. And there's a
There
lot
aren't
of
any proof
proved or admitted facts surrounding this issue. So it's not just a purely legal issue in a vacuum.
I agree. And if that's the way, well, I disagree, but I agree. If that's find it, then.
That's not the way I find it. It's the way decades of case law from our court and the Supreme Court find it.
Well, you remand it back and say, we think this issue should have been.
That's generally not what we do on failure to preserve.
I agree, but judicial estoppel is
Right.
an unusual defense. It goes to your integrity, not to what the parties said.
But our standard for judicial estoppel is actually different than the federal standard.
It has not been
No, it is.
extended. Yeah, it is different. But it's very broad too. It's said under a wide variety of circumstances. In the state of Belden, language this court used was very broad.
And why wasn't it raised below?
Wasn't trial.
He was- But if it's a very broad, well-known concept,
I don't want to throw
an applicant.
my fellow co-counsel under the bus, so I don't know. Unless you have any other questions,
Okay, thank you. I think we understand completely.
thank you.
Thank you very much. Thank you for a great briefing on both sides, very informative arguments, and we will get a decision out as quickly as possible.